Anita Amarichinda, and I welcome you to IP series where I talk about recent IP cases and developments globally. Now, this could take the form of copyright, trademark, patent, industrial design, trade secret, plant varieties, geographical indication, and biotech. If this is your first time joining us, please favorite my podcast on Anchor. I know that you can listen to IP series on Google and Apple Podcasts, Breaker, Radio Public, Listen Notes, and Overcast. So today's IP news flash: Taylor Swift was recently sued for a trademark infringement in the name Evermore. So Taylor Swift has an album titled Evermore, and a park in the US called Evermore Park sued her, claiming that her album title was infringing on their name. And we know that when it comes to trademark, um, names are protected. However, the title of an album cover cannot um, enjoy copyright protection, but rather um, it may enjoy like a trademark protection, especially if you know it the registry or the trademark examiner deem it fit to be distinctive enough. Um, but yeah, comments from the US jurisdictions are coming in, and some persons feel that the right step Evermore Park should have taken was to do like a collaboration with Taylor Swift. Others are saying there's no likelihood of confusion because they're not in the same line of business. Taylor Swift is a musician and an artist, while Evermore is a service product. So yeah, that's it for IP Flash News, and on to today's topic. Drum roll, please. So today's topic is, whose IP is it anyway? That is Oloture. Whose IP is it anyway? So sometime in November, the publication came out as to how Ebony Life Media had um, infringed on the copyright of Miss Tobore, who is an investigative journalist. And I think one of the basic things when it comes to IP that Nigerians fail to understand is the principle of ownership and authorship, whether it's for a creative person or an innovator. Since that's like the bedrock of IP, those are the two main um, people who build on intellectual property. So last year we also had a similar case on copyright infringement where Oge Obi was accusing Kiki Modu and BBC of infringing and using her story. However, what differentiates these two stories is that in the Kiki Modu story, Oge Obi was an employed staff of BBC, while in this Miss Tobore's case, she had started this investigation prior to her being an employee with um, Premium Time newspaper. So I'm just going to get right into it. As tradition, I always give like a background story into our topic. So sometime in November 2020, I already stated that I came across a publication of an alleged copyright infringement and IP theft in relation to the movie Oloture, which premiered on Netflix on the second day of November 2020. And then in 2021, Mr. Boro made another video, like she was granted interview to Pulse TV, which went viral like 4 weeks ago, and that sparked a lot of conversations on intellectual property, IP ownership, IP theft, rights that exist in a copyrighted work. Everyone just kept going, oh, it's her story. They should have done this. And I'm like, okay, okay. And because I had not watched the movie, I didn't want to, do my normal IP thread. But I had three people reach out to me via WhatsApp, and I told them I hadn't watched it yet. I've been following the story, but I hadn't watched it. Then I had another colleague send me the Miss Moabudu's um reply to Tobore's video, and I said, okay, I can't keep shying away from this. Let me just do my research and share my thoughts. So I watched the movie, then I went back to that article published in November. Then I read Tobore's interview. Then I also watched Marabudu's response, and then I started to, put the pieces together. So if you have watched Oloture, let me know what you think. Did you enjoy the movie? What did you think? Did you think like there's like a coincidence or similarities between Miss Tobore's story that was published and Oloture as a movie? So at the end of this, I'm going to tell you guys whether or not Miss Tobere is the real copyright owner, or Premium Times, who was her employer, is the copyright owner, and who Ebony Live Media should have obtained consent, permission, and authorization from. So on the 22nd day of January 2014, Miss Tobore's investigation report on From Sex Work to Slavery and Murder was published via Zam magazine. If you follow me on Twitter, I already put the link to that. Turns out that she had pitched the story to Zam and then started working on it. And by the time she finished the investigation, she had signed an employment agreement with Premium Times newspaper, which is one of the most read newspapers in Nigeria. She signed the agreement to be a full-time senior reporter, um, and because of that, Premium Times went ahead to also publish Tobore's investigative report, which she has started as a freelance journalist. Um, so under our Copyright Act, Section 10, Sub 1, that subsection 1 states that Miss Tobore is the first and initial author of the work. And an author, like I've stated before, is the person who created the intellectual property, while the owner of the work is the person who contributed, say, informations or suggestions, but not how the work was expressed at the end of the day. And in this Tobore's case, which she had pitched to Zang magazine, she wasn't tied to anybody that someone will come and say, oh, she was employed or I commissioned her to do this research. And this is where subsection 2 of section 10 comes into play, which provides that the only time when someone can be the first author is when the work is commissioned or it was made in the course of employment. So you can see that I'm laying the foundation as to how Miss Tobore, is the true and first copyright owner. And unless otherwise stated in writing under the contract, and looking at Tobore's contract, there's nothing like that. But let's take things a bit slow. Now, I asked a question on Twitter. I said, does Tobore's contract with Premium Time state that any work produced by her will belong to the newspaper company? And the answer is no. What the contract states here is that Tobore cannot engage in private work in competition with the company, and Any information obtained in the course of work must be treated as confidential and may not be disclosed to a third party without the authorization of the company. So nothing on intellectual property um, ownership that Premium Times will go ahead to say, oh, they're the owner of the work. And I also asked another question: does the fact that she was employed by Premium Times mean she had transferred her intellectual property rights that were exclusive to her as the first author? Now, according to the poll, 81.3% voted no, while 9.4% voted yes, and 9.4% also voted that they were not sure. So the answer is this: the fact that she's employed doesn't mean that she has transferred her IP automatically. The only time Premium Times can say her investigative report belongs to them is if the contract which she signed with them states that any work done in the course of employment belongs to Premium Time. And in this case, Tobore had started this investigative report prior to her being a senior reporter with Premium Times. Now, as an intellectual property owner, there are rights exclusive to you alone that you can commercialize or exploit. And if anybody wants to use your work, they would need or require your consent, your permission, and authorization. Without that, anything they do contrary to that will be considered to be an infringement. So Section 6 lists out the rights that are entitled to an IP owner for a literary and musical works, and it states that um, copyright in the works shall have the exclusive right to reproduce the work, publish it, and adapt it. So you can read paragraph 1, 2, 4, and 8. Now you can also read section 1, which lists literary works as an eligible work for copyright protection. Um, Going further, section 6 sub 2 provides that the right of the author shall be in respect of the whole or a substantial part of the work, either in its original form or in any form recognizably derived. Now, the key word here that we should focus on is whole or substantial part of the work, either in its original form or in any form recognizably derived. Now, if you've watched Oloture, if you've read her publication, that's the investigative report published both by ZAM magazine and Premium Times, you will notice that there are some similarities between Miss Tobore's story and Oloture story. And in the poll I asked if people noticed or recognized some sayings and immediately thought about Tobore's story. Now 69.6 voted that yes, that they had recognized and noticed something. So what they are trying to say is that they noticed substantial part of Tobore's work was used in Oloture. 26.1 stated or voted maybe a little. So they could notice certain things about Miss Tobore's story and also the Oloture movie. And then 4.3% voted saying, really? Yes, really. Did you really notice anything between the story and the movie? Please, 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 let's just be honest. Now, depending on your answer, was it substantial or whole? My answer is that there was a substantial part of Miss Tobore's story being featured in Oloture. Now, the votes came in and it said 72% said they noted a substantial part, 12% said a whole, 16%, oh my god, 16% voted make them settle. I'm sure they will, but let's be honest, Did you or did you not notice something substantial or whole about the movie? Now I will go further to ask, have you watched Oloture? Me, I just watched it last month, 27th to be precise. I took my time and watched it so that I don't misinform my listeners and readers. And 72.2% voted yes, it makes sense. While 13.9 said no, I don't have a Netflix account, and 11.1 said sub for me now. So if you're among those that clicked on that, I don't know if you meant if I should subscribe so you can watch it, or I should give you an account. Just let me know by sending me a voice note or an anchor here. While 2.8% voted I am waiting to download. I mean, that's really heartbreaking. I never expected people to vote on that. I was expecting to see like maybe like 99.9 or 90% saying, oh yes, I've watched it and it makes sense. But to see 2.8% say I'm waiting to download, I don't want to take it that you're just trying to be mischievous. I mean, your vote counts, and your thoughts are valid, invalid. But yeah, I mean, we shouldn't encourage illegal downloading. You need to, encourage these creatives who are creating content or making content out there by buying or streaming, doing it legally, not illegally. Now, on publication, I would like to know what the publishing policy of both Zam magazine and Premium Times magazine. I mean, so, like I earlier said, when it comes to copyright, it's your contract that determines whether or not you own your work. And if these newspaper or media houses do not have a contract or have any IP policy, then I mean that's really bad. But I feel they should do something about it so that we don't keep having these um cases. I mean, we should have them for precedent's sake, but yeah. So yeah, so I asked, um does the fact that your work was published, say by a journal or somewhere, mean you have transferred your IP rights, or you just licensed it? So 5% said I've transferred my rights. I mean, you haven't. It's only a contract that states that. I mean, you need to understand contract documentation, very important. 60% said license it Biko, which is like the right thing to do, like a way for you to commercialize and export your content. 35% said I'm not sure. I mean, what are you not sure of? Whether or not your right was transferred, or whether you need to license it, which is why you need to have an IP lawyer on your team. You get. The Zam magazine and Premium Times get Tobore's consent before publishing her report? I would say yes, absolutely, because you can't just go ahead to publish her content without letting her know at the end of the day. And then I asked, can it be now said that because they published it, Tobore, who is the author of the work, um, licensed it to them? I would say yes too, because that's like an exclusive right reserved for the first author or an author of a creative content. Um, you give a non-exclusive license to different people to publish your work or adapt it or whatever. Just you exercising the exclusive right you have as an IP owner. So anyone who now wants to use a substantial, so do you think a publisher own the copyright to your content even without a contract? Um 94.1, oh my god, 94.1 voted no. For what now? And 5.9 voted yes. A publisher doesn't own the copyright. Rather, what they do is put a copyright notice at the end of the publication. Now, because Tobore claims that um, the story was her true life story, I'll be taking a different dimension to this display. Looking at this from the true life perspective, that what are the intellectual property rights that exist in a work such as Tobore's story that ends up being adapted into a movie. Now, an adaptation is said to be a right accorded exclusively to the author, giving them freedom and authority over how the work is going to be used. And since IP is territorial in nature, it means how the work will be used within Nigeria. See section 6 paragraph. Section 6A paragraph 8, and also according to section 52, which is like the interpretation section, it defines an adaptation as the modification of pre-existing works from one genre of work to another and consists in altering work within the same genre to make it suitable for different conditions of exploitations, and may also involve altering the composition of the work. It is also that adaptation is also defined as a replica of the original content and is very common in say a cinematography film such as Oloture, which Ebony Life Media chose to narrate to a bigger audience through a different form of presentation. That is, now we're moving from a published work to a film or a movie. When we're talking of adaptations as an IP, we'll be talking of rights that can be licensed or transferred and documented into a marketable concept, thereby giving it a new work by signing an option agreement to secure the right to use the material in question before the studio commences shooting. And then when it's now made, the copyright owner, that's the first, let's just put it the copyright owner, who in this case is Tobore, based on based on section 10, someone which um states that Tobore is the first author of the work, will be paid an agreed fee to allow Ebony Life Media use the her story and adapt it into a film. Now, a publication by the World Intellectual Property Organization states that a right purchase agreement to be negotiated while staying stating the terms for securing rights to the screenplay, TV rights, and the right to release in ancillary markets such as home videos and new media like um, Netflix. What this means basically is that um, an agreement called the right purchase. So you're purchasing the right to, you know, to have a screenplay, to have TV rights, and also when you eventually showcase your work in the cinema, you own the rights because it's a new work that was created at the end of the day. Now, based on life story rights, um, movies like I don't know how many people saw When They See Us, which is was a true life story of the Central Park Five, who were wrongly accused. 12 years a slave, a true story of Solomon not up, an African American freeman who in 1841 was snatched off the streets of Washington and resold as a slave. Then Loving, the movie about the first interracial couples. And these are examples of life stories. And I'm saying, well, I had to lay this foundation because of Tobore's peculiar case where her own true life story was published and eventually was an inspiration for a movie titled Oloture. Um, However, what I'm trying to say is that for a life story, if you need to adapt it, if you're going to adapt it, you need the permission of the person who the story is about. And in this case, that's Tobore. You need her permission, you need her consent, you need her authorization to go ahead and adapt her story into a movie. If not, you're going to be having copyright issues, which we're already having. And because, when that, like I said, when that first publication in November was made, it was titled Copyright and IP Theft. And I was like, okay, not for a big brand like Ebony Life. But then when it comes to, um, infringement and IP theft, there's no big man or small man. Anyone can be a victim. So I was trying to be naughty, and I just kept, repeating these words: Tobore, Oloture, Tobore, Oloture, Tobore, Oloture, and I was like, I think this, sounds a bit similar, and I just said, okay, let me just include it as one of my polls, and surprisingly, 50% said it wasn't similar. And I was like, can't you guys see it? Like, just keep pronouncing it and repeating it. Tobore, Oloture, and maybe you might see what I'm saying. But that's me just pushing it too far. However, 41.7% stated that it was similar. So yay. But 8.3% said it was just a coincidence. So I think I might just agree with that. There was a mere coincidence, the title of the movie, the name of the first author um, of the sex trafficking movie. So moving on now, on a creative level, when you're writing your script for a film, you need to have like a storyline, and that is, it has to be both true to life and hold some potential as a movie, and which is how Oloture came to, exist. And even in the credit, it was said that Tobore's story was an inspiration. Inspiration, man. So I'm going to talk about that later on. But for works like Oloture, copyright is like the mother of all IP. That's like the first IP you should think of. That's for a film or a literary and artistic work. If you're thinking of copyright, first I think considering trademark and merchandising and stuff like that. So for content like Oloture, which is a film, and the story written by Mr. Bure, copyright is the lifeblood and the mother of all IPs you should consider when you're dealing with works like that. However, for this particular dispute now, everyone wants to know who owns the IP. And I set up a poll. I had four options. So Mr. Bore, Premium Times, Zam Magazine, and federal government. 8.3 voted for the federal government, 0% voted for Zam Magazine, 16.7 voted for Premium Times, and 75% voted for Ms. Tobore as the owner of the IP. And I will agree with the 75%, not because of Section 10. I'm relying on Section 10, but then it's too obvious that it was Tobore's story at the end of the day. Now, one interesting subsection of Section 10 is that where a literary, artistic, or musical work is made by the author in the course of his employment by the proprietor of a newspaper, that's the owner of a newspaper, magazine, or similar periodical, under a contract of service or apprenticeship, as is so made for the purpose of publication in a newspaper, magazine, or similar periodical, the said proprietor shall, that is the owner of the magazine or newspaper, shall, in the absence of any agreement to the contrary, be the first owner of copyright in the work so far as the copyright relates to the publication of the work in any newspaper, magazine, or similar periodical. And that is not the issue here for Mr. Bo. Now, it will go further to say, to the reproduction of the work for the purpose of being so published, but in all aspects, the author shall be the first owner of the copyright in the work. And remember that Section 10, someone has stated that the person who creates the work is the first author. So that means Tobore is the owner of this work, and Ebony Life Media should have had whatever interaction more with Tobore you know, we need to adapt your story, give us the permission, the consent and authorization. We're going to give you XYZ, blah blah blah. So apparently they had agreed on a certain percentage when it was, you know, released in the cinema. But it turned out that it ended up being released via Netflix, and Tubere started to feel somehow. You see why it needs to document certain things, because even this subsection 3 says that where there is no contract, in the absence of any contract, it is the proprietor. So it says the said proprietor shall, in the absence of any contract, be the first owner of the copyright. So if Tobre does not have any contract with um, Premium Times on IP ownership, that means that it's Tobore that's going to be the author of the work. A contract is what states or determines who is the owner at the end of the day. I hope that's clear. So I went for that. Do filmmakers really need to acquire rights in work? And 50% said yes, 20% said no, and 30% said not sure. So if you remember what I've been saying, consent, permission, authorization is very important. You need to get the right permission from the right author, the first author, um, for whatever content you want to create out of their already existing work. So yeah, a filmmaker needs to acquire life rights in a work um, whenever they decide to make a movie from someone's life story, or they are inspired to adapt it. It is best and advisable to get the right to commercialize the work in question. I know that people can, write stories on trafficking, domestic violence, climate change, but when it's something personal, like someone is giving their own experience, then we need to understand that there are instances where you may cross the thin line between inspiration and copying, and that could end up leading to an infringement when you take the the way the story was expressed or written, but just tweak it a bit. That becomes an infringement, because it's gives without the consent, permission, authorization, which gives the author's work its originality and also grants the author exclusive rights. Um, it also goes to show that you don't value the sufficient effort that was put in the creation of the work, especially since the work was created in a fixed medium. So you can read section 1, paragraph section 1 sub 2 paragraph A to B to understand um, what makes an author's work to be original. In a situation where Tubure's report was a source for your research, would you need her permission or Premium Times permission? Now, um, according to the poll, 28.6% said you will need Tubure's permission, you will need Premium Times permission, and another 28.6 said it was for private use, and another said you've already referenced her, so you don't need her permission. So let me explain the private use aspect. In an instance where you're using the report not to generate income or make money from it, it falls under the fair use principle, or fair dealing principle, depending on the jurisdiction, whereby you can use someone's content, either a substantial part, for say research purpose, private use, to criticize, do a news report, and that was not the instance here. Now, um, another issue now is, what is the purpose of your use that would require you going physically or informally or formally to meet Tobere, who is the first author and also the publishers, and that's Premium Times newspaper, to get their consent to use the work. So yeah, that's about it for that. And again, like I said, everything boils down to the amount of content that was used, which is why, for academic purpose, you're advised to cite or acknowledge or make reference to the author of a publication that you're using for your research. Um, Anyways, by publishing the report to the public, it now means that Tobore's report is now in the public domain. That's anyone can see it and read it. However, if you now decide to use it, you need to make a formal request to use it. I know there are some schools that, okay, so while I was doing my master, I had instances where if you needed a particular journal or something, the school will have to write on your behalf to the library that owns a copy of it and then send a copy to you. Um, that's about it. But when I talked about the report being in public domain, it did not mean that Tobore's um, term of duration for the protection of the work had expired, but rather it's now in the public eye, like it's now on the internet, and it is um, only the author that has the right to exercise her exclusive right given to her as an IP owner, and dictate how she wants to use it. And so, in order for you to obtain the necessary rights, you would need to consider acquiring the rights. That's the life right from Sobere, whose personal account was published and is the first author according to Section 10, Sub 1. And also, you need to also acquire the rights from the publishing house, as the newspaper, which Ebony Live, Miss Moabudu has said that they had acquired rights from Premium Time. But then, what they should have done was get both consent, permission and authorization from Tubere. So you're getting the life rights from Tubere. So Tubere wants to do a movie about you, blah 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 blah. Then you now go to Premium Times. So Premium Times, being the publisher of Tubere's story, will also need your permission to use some, make reference to it for use it as an inspiration for our script, all those kind of things. um, and again, the newspaper will not direct them to Toboro, who is like the first author. So you need to also determine chain of title when you're making your investigation. It's also very important that filmmakers do all of these things and realize that an author has both economic rights to benefit from their creation, commercializing and exploiting, and also moral rights to determine or have a say as to how that content is going to be used. So I want to do an adaptation. What are you taking out? What are you amending? What are you adding? What are you removing? If the boy say no, I don't like this, you need to do this, and you have to listen to her because that's her moral right. However, in an instance where she signed that off, then she can have a say with regards to that. On authorship in a copyrighted work, who can actually claim to be the author of a work? So now, according to Section 12, Sub 1, any art listed as being the exclusive right of an author, except when the work is included incidentally or accidentally when reporting current events by means of broadcasting. And this was not the case here. Tobore's investigative report was not, broadcasted while they were reporting current events. So what that would mean is that it's only Tobore that can claim, that has the right, the exclusive right of an author to claim authorship in her investigative report. Premium Times was not reporting any current events and therefore do not have any right to claim authorship. Now you may ask, what about the contract that Tubore had signed with Premium Times? Well, that contract did not state that the newspaper had the right to have publication. However, in an instance where a contract exists, it may be said to be that there's an express or implied right that the employee shall remain the first owner um, in accordance with Section 10 sub 1, which says that the initial creator of a work is the first author. That the author shall be the first owner of the copyright in the work. So you see that I have posted the contract in my tweet. And again, it's a contract that determines who has the right to claim authorship. And this contract between um, the employer and employee, that's in um, Tobore's case, appears on the work or copy of the work. That means there's a presumption that the work in question was not made in the course of employment, basically. So Tubore did not start this investigation while she was an employee. It wasn't given as an assignment to her as part of her roles and responsibility. It was something she had pitched while she was a freelancer, and then she got a job offer, and then um, the rest and everything that happened. So now I asked the question: do you think that the principle of implied license will apply in this case, especially when the author has a right to object and seek relief in connection with the dispute? And 66.7 said yes, that impliedly Tubure is the owner and author of the work and therefore has the right to claim um, ownership, while 33.3 stated um, there was no implied license here. And then I went further to explain that an implied license in a copyrighted work means that um, where consent, permission, and authorization is permitted for the intended purpose, um, for instance, in a commissioned work, the commissioner, that is the employer in this case, who is the person that commissioned the work, would have to sign a written assignment because there's no automatic right to the copyright anymore. So in a commissioned work, you cannot just say, oh, because I've commissioned, that means I'm the owner of the work. No, it's not it's not as automatic as copyright is. Copyright is the only form of IP that gives the creator an automatic oh my god, an automatic form of protection, whereby from the moment it's created in a fixed form, you've started enjoying copyright protection, which is why the law states that it's the first person that creates the work that is the first author of the copyright work in question. Now, the right to claim authorship or to be identified as the author of a copyrighted work is not automatic as with copyright, which is automatic upon creation. It must be clearly stated in writing, either by an assignment or licensing of the copyright, that the copyright or the person that needs to be identified as the author of the work is XYZ. Without that, you can't claim anything. However, subsection 2 provides that these exclusive rights are perpetual, inalienable, and imprescriptible, while section 25 talks about infringement, what occurs when a person who, without the license or authorization of the owner, does any of the things prescribed in section 6. That's talking about the exclusive right of an author. So I'm going to backtrack a bit and talk about the subsection 2 of 12. So that's with regards to so I already stated that an author has two rights: economic and moral rights. Now, these rights are forever. It cannot be taken away except where you sign a contract to that effect. Where you do not sign a contract to that effect, then it's forever and ever. And I've had an argument with someone where the person has stated that subsection 2 was referring to the moral rights, where your moral rights are perpetual. And I said that's not true, because when there's a moral assignment and transfer of moral right clause in my agreement, I cannot come to me and say, oh, even if I sign that, I still have a right to say as to how my work is to be used. No. Nay, you can't do that. So I'm just going to move forward and talk about infringement. We already know that you can file an infringement suit at the Federal High Court according to section 16 sub 1, and the following are the things that you can get if you file a suit, which is called a relief. So you're entitled to damages, injunction, and also an account of profit. However, subsection 3 and 4 provides that where a suit for infringement has been filed and it's been proved and admitted that an infringement was committed, and at the time it was committed, the defendant claims not to be aware or had gave a reasonable ground that um, he suspected that copyright existed in that work, the things you can claim for includes just an account of profit. That's the only thing you're entitled to. You're not entitled to damages or an injunction. You're only entitled to an account of profit. So in this case now, what Obere can do is she can apply. So depending on how they decide to go, so if Ebony Life is claiming not to have known that a copyright, Tobere owns the copyright in the work, then Tobere is only entitled to a profit of account. But if she can prove beyond reasonable doubt that Ebony Life and Moabudu knew that she had copyright but still went ahead to use her work, then she's entitled to damages, injunction, and also an account of profit. Not a judge, just giving my own view before people start to quote me, but yeah. So, in your opinion, from everything I've talked about an infringement, do you think Ebony Life infringed on Tobere's work? My answer is yes. So I'm answering most of my questions in my podcast and not in my tweet, because I had a comment from someone that said I left so many questions unanswered. So yeah, I do feel there was an infringement, so parties should go ahead and discuss how to settle. So according to the poll, 80% said um, Ebony Life Media had infringed Tobere's work, while 20% said let the court decide. I think I would prefer if the court decided on this. That way we have a precedent with regards to the subject matter, and that will also deter people from doing stuff like this in future. So copyright infringement occurs when you do acts in relation to the whole or substantial part of the work without the author's CPA, which I say is the consent, permission, and authorization. So, what is a substantial part and indirect infringement? So, a substantial part is when a work is made or created according to how the copyright work was expressed, um, which will now lead to an indirect infringement, even though it wasn't um, everything that was copied. So when it comes to infringement, it's about how much was how much of the content was copied at the end of the day. And this will depend on the quality and not on the quantity. Um, Especially when you're looking at the author's skill and his judgment that contributed to the creation of the work in question. So, when we now ask and say what can amount to copying, Section 51 defines a copy to mean the reproduction in written form, in the form of a recording or cinematograph film, or in any other material form. So, what that means is that an object shall not be taken to be a copy of an architectural work unless the work is a building or a model. So I had asked if people thought there was like a casual connection between Tobore's story and Oloture, and 100% said yes. Um, so how do you prove an infringement? Especially in this case now, it would be said to be that um, the work was copied either consciously or unconsciously, and that they had prior access to the copyrighted work. And in this case, that would be Tobore's published investigative report, which Ebony Life Media has said their scriptwriter had relied on, and also her story was like an inspiration um, for the movie. So did Ebony Life Media and the scriptwriter have access to Tobore's work? Yes, of course, which 100% agreed with me. Now, was Tubure's investigation a duty to Premium Times? I would say no. However, in the poll, it was like a 50-50 vote. 50% said yes, 50% said no. My own, I'm voting um, no. It wasn't a duty to Premium Time. It was like her own project which she started. Um, was her skill, effort, and judgment um, a part of her normal duties, whether expressly or impliedly? So 66.7 said expressly. That means it was stated. Implied in 33.3 said it wasn't stated, but it was expected of her. I don't think you can be expecting that from someone when you haven't told the person what their rules or roles and obligations are. So I'll go with expressly. So, what are the issues that may arise from, say, be a copyright issue or a life story issue? Issues that may arise: one, issues in right of publicity. So, Tubere, who is like a an award-winning investigative journalist, she has attained some form of a celebrity status or a public figure status. So she has the right to prevent people from using content relating to her or regarding her or about her and without her permission, or trying to mislead people to say, oh, somebody gave me the permission to do this, so yeah, I'm doing it. Nah. Then you also have issues on invasion of right to privacy, but that's a bit tricky because someone might argue that because she already put her content, her story out there, she doesn't deserve any right to privacy. That's not true. Um, I don't think she, said everything that really happened to her in the course of the investigation, but she still, put her story out there. So she deserves some privacy. I put my story out there, but I still need, my peace and quiet. If you're going to disturb my peace or interrupt with, that. I know she's talked about, still having nightmares and, going for therapy because of the rape incident. Um, Another issue is IP infringement and theft issues. That was what started this whole conversation. Ebony and Moabudu stole my copyright, IP theft. That's like the first article I saw. So you need to be very careful with that. And then in an adaptation, economic right is affected. So the right for the first author to commercialize and make money from her work, benefit from her work, is affected, while the moral right is increased. So it's all about the moral right here. The question is, did Tobore give them the permission to adapt it? Okay, even if she did, how much did she ask you guys to alter? How much did she approve? I mean, she should have been taken through the whole process, even at the scriptwriting. So if you've watched 50 Shades of Grey, the making of the movie, you will see that the author was involved in the shooting, the scripting, everything. So she said, okay, you need to remove this so it doesn't, get some sort of backlash. Because when people, if you've read the book and watched the movie, you see a lot of different. Same thing with, books that have been adapted, Harry Potter and the rest, Games of Thrones. You get my point. So those are the things those are the issues that may arise in a dispute like this for me. My recommendation: one, always involve an IP lawyer well grounded in copyright law at the script stage before you even commence shooting. It's very important. And I'll tell you why. So that they can help you do like proper research, determine the chain of title, ownership, authorship, when all these questions arise. Because I feel if they had done the needful, tomorrow will not come out and start saying all of this. I think everything would have been sorted. Hush hush. Nobody even know. We only hear, oh, Tobere story, her investigation report was an inspiration. That's all we'll hear. But now Power don't open. Anyways, you need to also verify your source. Find out what the law says or provides with regards to your industry, with regards to copyright and ownership and authorship. Then draft and sign an agreement that includes a new media to be used for distribution. Very important. Documentation is what will save creatives and innovators, especially in this Nigerian sector where everyone is trying to take advantage of the next. Everyone's trying to, get um, their own share from whatever it is. A contract with an IP clause should state clearly who owns the IP that was created, e.g., an employment contract. So you can say, in the course of your employment, anything you create belongs to the company. That one is stated there. But whereby and the person negotiates with you and say, no, how can you say that if I create a work, it's going to belong to you? I want to own the right. And you now start talking. You get and then I talked about that in my please don't call me or please call me patent case. If you can read, like, that was like one of my first IP series, so you can check that out. So we know that IP is everywhere. It's territorial in nature and also, interplays with every sector. It is best. Free advice, so retain an IP lawyer to avoid stories that to avoid stories that touch. Bring them in from the beginning of your project so they can give you the IP perspective of whatever project you want to do. Then always investigate the chain of title. So I think Moabudu and her team, Ebony Life Media, did the best they could, but they should have done more. I feel they should have done more. Confirm that all the economic rights and moral rights belongs to the first or belongs to the true author. Understand that there's a thin line between copying, inspiration, and infringement, and it all boils down infringement. It all boils down to the use of the work. And I quoted someone on Twitter at Rick Sanders Law. So that was in regards to another dispute that we saw within the week where um, um, someone who had created an animation film was saying another film director had copied word for word or scene for scene in his movie. And Rick says here, saying he he says, wow, saying you were inspired by something doesn't mean it isn't substantially similar to your work. Hashtag copyright. Or and just because it's on the internet doesn't mean it's ripe for the blocking. Bonus, proof of access. So proof of access is the bedrock. So you're starting from proof of access. You're talking about substantially similar to your work. You know all those things. So the case is about, like I said, and so someone by the Twitter handle at Moby underscore dickhead apologies has accused another filmmaker of said the film is a fully plagiarized shot for shot remake of my comic. The filmmakers didn't ask for my permission to adapt my work. They didn't even notify me that we were doing so until the film had already been released. I mean, this one is really bad. Like, no investigation, no chain of title was determined. They just said, okay, let's just shoot it, and then when it was done, they're like, okay, we have copied your work. Oh, we're just going to acknowledge you finish. Nothing. Like, you're supposed to actually compensate that person. But I think I'm digressing right now. But I think you guys get the gist. Proof of access, you know, another thing. Did you have access to that content? And Ebony Life, the script writers, they had access to Tobore's report. Was in the public domain. So, and in conclusion, Tobore to me is the first and true owner of that work, and she should have been rightly compensated. So I feel parties should renegotiate, which is where alternative dispute resolution comes into place. You can always negotiate, you can mediate. Um, However, just so you can set a precedent for us in future, we should please go to court and let the court decide. But yeah, let me know if you have an ulterior alternative opinion about the Oloture saga. Let me know who you think owns the IP in this case. And so we've come to the end of IP series for today. Let me know what you guys think about this episode. Whose IP is it anyway? Is it Tobore? Is it Premium Times? Is it Sam Martin? Who owns the IP? And you can also send me cases you want me to review. I'll do that quickly, guys, on Twitter, or I'll do a podcast version, or all of them. And next week, you guys, like a live